Hello guys, welcome back. This is a detailed video of what really happened in court yesterday. How Mazi Nnamdi Kanu's lawyer defended their no case submission file. Watch this video to the end to see and hear what really happened that made Justice Omotosho to adjourn the case till 10th October 2025. Stay tuned.
Welcome to the Deep Dive, your shortcut to being well-informed. Today, we're getting into a really high-stakes legal fight. It all turns on this big question. When do words stop being just, boasting and become something criminal, like incitement?
That's right. We're looking at the terrorism trial of Nnamdi Kanu. He's the leader of IPOB, the indigenous people of Biafra, which has been prescribed.
And our mission today is to really break down the legal arguments. We've got the prosecution, the defense, battling it out in front of Justice James Omotosho in Abuja.
And what's great is that our sources are straight from the court records. So you're getting a direct look at what happened during this key phase, the no-case submission.
Okay, let's unpack that term, no-case submission. For anyone listening who maybe isn't familiar, what exactly is that? It sounds important.
Well, it's crucial. It's basically the defense saying to the judge, look, the prosecution has presented its case, and frankly, there's just not enough there. Not enough evidence to even make us put up a defense.
So they're arguing the prosecution hasn't even made a basic, a prima facie case. Is that the term?
Exactly. Prima facie. Does the evidence, if you believed it all, suggest a crime might have happened? If the judge says no, well, the case could just end right there. Kanu could be acquitted.
Wow. Okay, so the main players involved, we've got Nnamdi Kanu, obviously, Justice Omotosho presiding.
Yep. And then the lawyers, both senior advocates of Nigeria, SANS, that's the top rank for lawyers there, Adegboyega Omolo for the prosecution.
And Kanu Agabi leading the defense for Kanu.
Correct.
So the absolute core of this, the main disagreement, seems to be prosecution says Kanu's broadcasts incited violence. Defense says, no, he was just, boasting. Big talk.
That's the crux of it. And this is where the law gets really fascinating and tricky. How do you prove intent? When someone says something extreme, were they really trying to get people to commit violence or just, puffing their chest out?
It's about the impact versus the intent, maybe?
Sort of, yeah. The court has to weigh the words, the context, the alleged consequences.
Yeah.
It's complex.
All right, let's dig into the prosecution's side first. What did Awomolo ask the judge to do?
His main plea was, reject this no-case submission. Make Kanu stand trial properly. Make him answer the charges. He argued Kanu needs to explain why he supposedly promoted violence and destruction through his activities.
And how did they try to back that up? What evidence did they point to?
Well, Awomolo claimed they had sufficient evidence. He mentioned 5 witnesses who testified and many exhibits, things like video and audio recordings of Kanu. He argued the judge just needs to look at everything together, take a panoramic view, he called it, to see if there's enough for a basic case.
Did they claim Kanu actually admitted to anything in those recordings?
According to the prosecution, yes. They argued the footage shows Kanu admitting he's the IPOB leader, knowing it was a banned group.
Okay.
And, crucially, they claim he admitted making broadcasts that called for violence and destruction. That's their interpretation of the words used.
Which brings us right back to this boasting defense. How did Awomolo counter that specific point? Did he just dismiss it?
He absolutely dismissed it. He argued that the law doesn't allow statements that cause fear. He basically said, you can't just excuse threats of killing security officers as mere boasting.
He drew a direct line then.
A very direct line. He explicitly linked Kanu's words, his boasting, to the deaths of security personnel. He said something like, not less than 170 security men were killed because of his boasting.
Wow, that's a stark number.
It is. Awomolo's point was clear. When a person is boasting and threatening death and violence, that cannot be said to be mere boasting. He essentially dared the defense to explain what else it could be, if not incitement leading to death.
Okay, strong stuff from the prosecution. Now, the defense raised some other points, didn't they? About how long Kanu's been detained or delays in the trial. How did the prosecution respond to those?
Right, Awomolo tackled those head on. The defense claimed Kanu was in solitary for 10 years. Awomolo said that's not right. He gave a timeline. Arrested 2015, got bail 2017, then jumped bail. Rearrested in 2021. So his current detention, Awomolo argued, is court-ordered because he jumped bail, not some arbitrary decade-long solitary confinement.
And the trial delays, who do they blame?
They pinned it squarely on Kanu's own legal team. Awomolo said they are the cause of the delay, flat out.
Okay. What about the IPOB prescription itself? The defense questioned if it was even legal.
Awomolo's response there was procedural. He said, look, the legality of the prescription is already a case before the Supreme Court.
I see.
So he argued it's not really for this trial court, for Justice Omotosho, to rule on that specific issue while it's pending higher up.
Okay, that makes sense. So let's switch sides. Let's look at the defense with Kanu Agabi. What was their overall take on the prosecution's case?
Agabi came out swinging. He argued the prosecution did nothing more than paint Kanu as a bad man, just character assassination, basically.
Without proving the actual charges.
Exactly. He said they failed to prove a single element of the offenses charged. That's a really strong counter, saying they didn't meet the basic legal burden on any count.
So how did they specifically push back on the idea that Kanu's words were incitement?
Their main point was, where are the people who were supposedly incited? They argued the prosecution didn't bring a single witness to court who said, yes, I heard Kanu's broadcast, and that's why I did something violent.
Interesting. So no direct causal link shown through testimony.
That was their argument. And then Agabi delivered that memorable line, this man, Kanu, can boast. He said, I can bring the world to a standstill. I don't see anything wrong with that. You don't prosecute a man for mere boasting.
Really leaning into the big talk defense.
Absolutely. Portraying it as hyperbole, not a genuine instruction.
Agabi also mentioned other public figures talking about self-defense amidst insecurity, didn't he? People like the DSS head and a former defense minister. What was the point there?
Yeah, that was clever. He was trying to normalize Kanu's statements, suggesting they weren't unique calls to violence, but were actually similar to what other prominent figures were saying about needing to defend oneself in dangerous times.
So contextualizing it within a broader national conversation about security failures?
Precisely. Trying to frame it as calls for self-preservation, not aggression.
Beyond just the words, the defense also went after the prosecution's evidence pretty hard, right? And the whole process.
Oh, definitely. Agabi raised serious questions about the prosecution witnesses. This was a big one.
What was the issue?
He counted. He said the prosecution witnesses answered, I don't remember, I am not aware, I do not know, a staggering 80 times during cross-examination.
80 times, wow.
Yeah. And Agabi's point was, how can that possibly meet the standard of proof beyond a reasonable doubt? It suggests their testimony is unreliable, doesn't it?
It's certainly raising questions. What else about the evidence did they challenge?
Several things. There was an hashtag NZARS report the prosecution submitted. The defense said it was unauthenticated, meaning its origin or reliability wasn't properly established.
Okay.
And then, the death reports for the security officers. The defense pointed out that the doctors who supposedly wrote these reports were never called to testify.
So no chance to cross-examine them on their findings.
Exactly. Which is usually crucial for verifying that kind of evidence in court.
It seems like they were trying to pick apart the foundations of the prosecution's case piece by piece. Were there other procedural complaints?
Yes, quite a few. Agabi accused the prosecution of being slow and unresponsive. He claimed they failed to even reply to 10 specific legal points the defense had raised.
Endpoints ignored.
That's what he claimed, arguing even one unanswered point should be grounds for acquittal. He also criticized the investigation itself, saying the DSS witnesses just took statements but didn't really investigate them. And he objected to the prosecution trying to add more evidence after the trial had already started, arguing that shouldn't count.
What about the charge sheet itself? I remember reading it was amended multiple times.
Yes, Agabi highlighted that amended about 7 times, he said. But even after all those changes, it still didn't name any specific individuals who were supposedly invited or incited by Kanu. Again, lack of specificity.
That seems like a significant omission if you're claiming incitement.
It could be seen that way.
Yeah.
Then Agabi shifted to more humanitarian and jurisdictional arguments. He brought up the solitary confinement claim again.
Right, but this time framing it differently.
Yes. He claimed Kanu has been in solitary for over 6 years, arguing international law generally limits it to 15 days. He made a pretty stark statement. He, the defendant, is no longer normal on account of his solitary confinement.
Linking the confinement to his mental state and maybe witness memory issues.
Exactly. And tying it into the whole length of the case the decade it's been dragging on. He also directly attacked the legality of the IPOB prescription again.
How so?
Arguing it's unlawful because, according to him, the prosecution never showed proof of the president's approval, which he claims is required.
Okay, another procedural challenge, and one more point on jurisdiction.
Yes, regarding a specific charge about an unlawfully imported radio transmitter. Agabi argued the Court of Appeal had already dealt with that issue, so this lower court, the federal high court, didn't have the jurisdiction to retry it.
Got it. So a multi-pronged defense strategy. Attack the interpretation of words, the evidence, the procedure, the jurisdiction, and even raise humanitarian concerns.
A very comprehensive no-case submission touching on almost every aspect of the prosecution's efforts.
So after hearing all of this from both sides, what happens next?
Well, Justice Omotosho listened to all the arguments, the back and forth, and then he adjourned the case. He set a date quite far in the future, actually October 10th, 2025.
2025, wow, that's a long wait.
It is, and on that date, he'll deliver his ruling. He'll decide whether to uphold the no-case submission, which would likely mean acquittal for Kanu, or reject it, meaning Kanu would then have to present his own defense.
So we've really walked through this intricate legal tangle, freedom of expression versus criminal incitement. It's clear how both sides are drawing their lines, isn't it? From how you interpret boasting to really deep challenges about evidence and fairness.
Absolutely, and Justice Omotosho's decision when it finally comes will be huge. Not just for Nnamdi Kanu, obviously, but it could really set a benchmark for how Nigerian courts handle these kinds of incitement cases moving forward, especially in the age of broadcasts and online speech.
It makes you think, doesn't it? As you listen to all this, what does proof really mean in court, especially when you're dealing with words and their potential impact? How much blame does someone carry if others act supposedly influenced by what they said?
And how does that idea of boasting become a legal shield or a weapon in the courtroom? It really forces us to consider that very fine, often blurry line between speaking freely and causing real harm. Something for you to definitely chew on.
Thanks for watching. Don't forget to subscribe, like, and comment.